Good afternoon to everyone. Can you hear me okay? All right. Well, if you can't hear me or I need to talk louder or softer, just let me know. Raise your hand. But I am Chris Brown with the Babb & Brown Law Firm in Greenville. We're in Malden proper, I would say, although we have a Greenville address. But we're in Malden, just a few miles down the road on West Butler Road in Malden, where I have practiced for more than 20 years now in Greenville. I grew up in Greenville on the east side of town off of East North Street. Went to Eastside High School, went on to Furman University to get my undergraduate degree, and then spent 3 years down in Macon, Georgia at Mercer University obtaining my law degree years ago, and it just worked out to come home. And I've enjoyed, I tell people now, growing up with Greenville the last 20 years. But there again, happy to be here. We have been making these types of presentations for 4 or 5 years now on elder care related topics. And by that I mean topics that our seniors within our community or their families are facing on a day-to-day basis, but in some respects issues that a lot of people face, sometimes unexpectedly. And today our focus is going to be a little narrow in the sense of we're going to talk about power of attorneys and medical directives, specifically healthcare power of attorneys and living wills being the two primary ones. When someone comes into my office and is asking questions about their estate or certain documents they should have, we may talk about different things. But normally during the course of the discussion, other than last will and testaments, which is not the focus today, but other than last will and testaments, 3 documents that we often talk about and share the importance of clients considering having them are general durable power of attorneys, healthcare power of attorneys, and living wills. So those are the 3 documents we're going to focus on today. We do have PowerPoint presentations, but rather than do that today, I just compiled a very brief handout that will have the majority of the talking points I talk about or share with you, and you'll have these to take with you and to read over after today or share with other family members or friends if you so choose. But those are yours to take notes on or to do with as you please. But my comments are going to follow along very closely to the handout itself. And the first main page, other than the cover itself, is titled Power of Attorney. And I'm going to start with some comments, share some information about general durable power of attorneys. And what is a general durable power of attorney? Well, a general power of attorney, general, is rather broad. And it encompasses many different types of legal, financial, business, money-related matters. It could cover someone going on your behalf to the bank to transact business for you. It could be someone calling your financial advisor, someone calling the company that has your retirement investment account, calling Social Security. As simple as picking up the phone and calling Duke Energy, Charter Cable to address an issue with an account that you have in your name. As simple as those things that you sit down maybe over a cup of coffee at the kitchen table, you make out your to-do list, and what may seem like some of the simplest tasks for you to do on a daily basis can become incredibly difficult, if not impossible, for someone to do for you if you do not have a power of attorney in place. But the general part of general durable power of attorney, the general encompasses all of those types of decisions, financial, legal, business, money-related decisions that you deal with within your home, within your personal assets, your accounts, normally will all fall under the general authority granted in a power of attorney. Now the durable, because that's a key word in most power of attorneys, but the durable states that the POA is not affected by physical disability or mental incompetence of the principal, that the POA can still be used by the person that you designate as your agent after you become mentally incompetent or disabled. Now, every one of the hundreds of power of attorneys that I have prepared over the years, everyone that signed their power of attorney was mentally competent the day that they signed the POA. Most often, they do not need the POA the day that it is signed. What they are doing is planning for the future. They are planning for if something happens unexpectedly, an unexpected illness, an unexpected accident. That could happen, that your life changes from one day to the next. And when you need the power of attorney the most is possibly when you no longer can go to an attorney's office and you no longer can sit down and share with him why you need it, because it may be too late at that point. Power of attorneys are 99% of the time, they're created, they're signed before anyone ever needs them. But in most cases, they will go into effect, meaning they can be used the day that they are signed or any day thereafter until the day that that person dies or voids, terminates that power of attorney and the authorization within it. Two terms I've already said, but I just want to clarify, is principal and agent. Principal is the person that is giving the power of attorney, the authority to someone to make decisions for them. The agent is the person that's receiving the authority, the person that will be able to act for the principal if and when they need their assistance. And the question that I pose right after this in the handout is, why would I need a power of attorney? Well, as I've already alluded to, South Carolina law does not give anyone the right to make these decisions for you. Sometimes, especially married couples, spouses assume that they can make those decisions for one another. Temporarily or permanently, if a husband or wife becomes ill or is in an accident, the other spouse just assumes that they'll have the ability to step in and make those decisions for their spouse. Well, unfortunately, when it comes to legal, financial, money, or business-related matters, you cannot. The state of South Carolina does not give anyone, not your spouse, not your child, your parent, your sibling, no one the authority to make legal or financial decisions for you. The only way that you can designate someone to make those decisions for you is by way of a power of attorney. Now, if you don't have a power of attorney, but you need a power of attorney for yourself or another family member, the state law does set up special court proceedings to help people attain the authority that they need to make decisions for someone. Legal and financial decisions are brought through a proceeding called a conservatorship through the probate court. If you need to make health care related decisions for someone, it is brought through a guardianship proceeding. So the state of South Carolina, as does every state in the Union, they have legal proceedings to help people and their families get the authority that they need to help that family member. However, those legal proceedings normally will last between 3 to 4 months. They probably will range between $2,000 to $3,000. And then the court is going to monitor your actions as a conservator or a guardian for the rest of that person's life, whether it's a few weeks, a few years, or longer. Most people, or some people, don't realize that just being proactive and making a power of attorney where you make the decision yourself of who you want to place in that very important position of being a power of attorney for you can be done simply with a power of attorney relatively quickly, within a few days, and then for much less cost or expense than those legal proceedings, and you have a document that may last you for the rest of your life. So we encourage clients when we talk with them to certainly consider the benefits of a power of attorney, and we're going to talk about them even in more detail now, because the powers granted to the agent only has the power granted in the power of attorney, but in a general power of attorney it's pretty broad. And I'm going to talk in a moment about some considerations in who you should choose as your power of attorney. And at the top of that list is someone that you trust, because it is a broad discretion of legal and financial decision making that you're going to be giving to someone if it's under a general power of attorney. We normally do not restrict the power of attorneys, meaning we don't limit the amount of authority that we give power of attorneys in most cases. We don't, because we do not know what the future holds. We do not know exactly what authority they may need a year from now, 5 or 10. So if you're putting people that you trust in this position, hopefully they will have the authority they need, whatever the circumstances may be at that time in the future. They will have the authority they need, and they will make decisions in your best interest because they have your best interest at heart, if it's the right person that you've appointed. Two things, though, I did state at the bottom of page 1, is an agent, the person that you appoint as your power of attorney, cannot make gifts to themselves or cannot gift your money or your assets to anyone else unless you specifically give them the authority to do that. And some people do within the general power of attorneys that we have. Just as you may consider one day begin to start giving some of your assets to your family members, your children or otherwise, not waiting till after your death and it be distributed through your estate, but you're going ahead and going to consider giving them, maybe it's your household furnishings, maybe it's monetary gifts. You're going ahead and considering giving those things to your family, maybe now when they need them. And that same discretion can be given to your power of attorney as well to gift your property, but it's a special authorization that we either add or take out based on the client's wishes. And also, a power of attorney cannot be used to deed property to yourself as a power of attorney. Meaning, if I had power of attorney for my mother, which I did for many years, I would not have been able to draw up a deed to her home and deed it to me using that power of attorney for $1 love and affection. That is considered an illegal transfer under the laws of South Carolina. Now, I could sell it to someone. If Joyce wanted to buy my mother's home and she was moving to an assisted living facility, and Joyce came and said, I would like to buy Mrs. Brown's home, I could negotiate the sale of that home. I could sell it to her just as my mother could have conducted that transaction herself, but I would have been selling it to a third party, and I would have been selling it for the fair market value or true consideration, meaning the value of that home. That's fine. That's a very common use of a power of attorney by either a spouse or a child serving as a power of attorney for a parent. But I did make those two designations there at the bottom of page 1 for you. The role of the agent, the person that's appointed as your power of attorney, I make a couple of comments at the top of page 2. The agent and the principal do have a fiduciary relationship with one another. And what do I mean by fiduciary? I simply mean that if you appoint your spouse, if you appoint your child to be your power of attorney, they are always supposed to act in your best interest. Not their best interest, but your best interest. They should be making decisions with that power of attorney. Every decision made should be, how is this going to impact the principal, whether it be a spouse or a mother or a father? How is this going to impact them? Is it going to have negative consequences or positive consequences, as in, is this in their best interest? That should be the question asked of the power of attorney before they ever act or make any decisions for the principal. That's a fiduciary relationship. And I will say that the agent is accountable not only to the principal, but to the principal's heirs. So I'll use my family, I often do, as examples. I have one sibling, I have a sister. And my mother, as I mentioned a moment ago, gave me authority to be her power of attorney many years ago. Well, I served as that power of attorney up until her death last year. Well, after her death, my sister, as an heir to her estate, could at that point, if she had not done so previously, could have come before the court and questioned my actions. She could have come before the court. Now my mother is now deceased. I no longer have the authority to act as her power of attorney because it terminates upon death. I'll reiterate that point later. But even after my responsibilities are done, my sister could have come forward and said, I do not agree with some of the decisions he made as power of attorney. I don't think he made decisions that were in my mother's best interest. I don't think he used my mother's monies for her interest. I think monies could have been misappropriated, misused. All of those allegations could be made against a power of attorney. So I caution, if you are serving in the role as a power of attorney, as the agent, it is very important to keep good written records of everything that you do. You may never have to account for it, but it's much more difficult to go back and compile those records a year or several years later than it is month to month, just keeping a record, keeping a journal of what you do and what checks you write, and making sure that you have documentation to prove that you are always acting in the principal's best interest if you are ever accused of doing otherwise. Now, it doesn't happen very often. As I probably have prepared, hundreds of power of attorneys. I can probably count on one hand 4 or 5 instances where I have had power of attorneys come to me at a later date and say, I think I have a problem. My family, my siblings, my father, they're not in agreement with what I'm doing for them. I need to talk to you about that. It doesn't happen often, but it can happen. And unfortunately, every person that came to me was not as prepared as they should have been to respond to the questions that were being asked of them, because they never thought they would be asked. They never thought their actions would be questioned. and they may not have ever made a bad decision, but the questions can still be asked. The next item I have is choosing an agent. So you can probably, from just what I've shared already, these things are not going to be a surprise to you, but choosing someone you trust and will always have your best interest at heart is important. Choosing someone who can be contacted easily and can be readily available to assist you. Choosing someone with experience handling finances is a consideration, but not the primary consideration in my opinion. And choosing an alternate, which I'll come back to. The reason I say choosing someone with a financial background to make legal and financial and business related decisions should be a consideration, but not the primary consideration. And this is just my own opinion. I feel it's more important to have the person that you trust that will always make decisions in your best interest, regardless of their background or their experiences in finances, because they can reach out to someone else for assistance. They can retain an attorney to help provide them legal advice. They can retain a financial advisor to help manage your monies and help provide valuable financial advice. But just because someone has a financial background doesn't mean they're an honest or trustworthy person. And sometimes that background, if they are untrustworthy or dishonest, just lends itself to being able to take your money or misappropriate it easier because of what they know and their experience. And choosing an alternate is very important. It's probably the most important decision of the two. You'll select one primary power of attorney, but if that person, for any reason, due to death, disability, or otherwise, can no longer serve in that role, we strongly encourage clients to have a substitute, at least one person as a substitute. And quite often it will be a husband and wife that will come into the office, sit down and say, we want to make out power of attorneys and we want to name each other as our power of attorney. We trust each other unconditionally. That if the wife states, if I cannot make my decisions, my husband has full authority to make them for me. And the husband will often reiterate the exact same words. If I'm unable to make my decisions, I certainly want my wife to make any and all decisions for me and our family, to conduct our family business just as we have for so many years. And that's the easy decision. But chances are, one of the spouses will outlive the other. They will at some point in the future will not be able to rely upon each other. There will be an adult child. There will be someone else that will have to step in, transition to a caretaker role at some point in their lives. And that's the person that probably is going to be caring for you or your spouse when you are the most vulnerable, when your health is beginning to decline. You need help the most. You really need to rely on that person because you no longer can do what you could do 10 or 15 years ago. That appointment is very important. If it's a child, well, we encourage you to consider a child that is going to be very fair, because often there are other siblings. And in most families, at least my own and many others that I meet with, not all siblings get along all the time. So it's important to consider, if you do have to select a child to be that substitute, or even your primary power of attorney, that it be someone that you feel like will be impartial, can treat their siblings fairly, can take the heat if it gets a little hot, and they try to always be focused on you and what is in your best interest. But that alternate appointment is very, very important. I do get the question often, well, what if my husband is deceased, I have 2 children, I trust them both, can I appoint them to be both my power of attorney? You can. It's not illegal. You can do that. You can appoint 2 people. But I do caution clients that you are setting up a scenario that if they do not communicate well, if they do not cooperate well, if they're not willing to come together and make decisions that are in your best interest, some decisions that need to be made may not be made in a timely manner when you need them to act for your benefit. But even with that explanation, I have had clients that have elected to have co-power of attorneys. And sometimes, as long as your family works well together, communicates, cooperates, and will always focus on your best interest, it may never be an issue. And that may be a case of where I mentioned in my mother, she had 2 children, myself and my sister. I think she trusted us both, and we would not have had a problem had it been a co-POA, because sometimes my sister was with her. I couldn't get off work every time my mother needed something, and sometimes I was there and my sister couldn't be there. So she would have had the flexibility of having either one of us available to assist with her banking or other needs as needed. Another comment I want to make regarding the POAs, I did mention earlier, and I just kind of went right past this statement very quickly, but the power of attorneys go into effect the day that you sign them, normally. If you do not want them to go into effect, you have the ability to put what is known as a spring, like summer, spring, fall, winter, springing mechanism. That means there's a trigger. The power of attorney has been signed, it's been executed, but it cannot be used until something happens. And that trigger is your mental or physical disability. And I do have clients on occasion, not the majority, but I do have clients that feel strongly that they want to make their own legal and financial decisions until the day the doctor says you can no longer make them. That they do not want anyone else to have authority to make those decisions for them. And we will provide that springing mechanism, that trigger in the document. But, and now I step back and I speak from personal experience. I told you I was my mother's power of attorney, and she executed that power of attorney in 1995. It did not have a springing mechanism. It could have been used the day that she signed it. I could have as her POA. For 18 years, I never had to even look at that document. It stayed in a file in my office. I never even had to look for it. And then her health changed. It began to decline. And I had to step in and start serving in that role as power of attorney. There are times I had to go to the bank. I had to call regarding her investments. I had to initiate a long-term care application for her. I had to go to the DMV and get her handicap sticker for her car. I could go on with the things that I had to do for her over that 2-year period of time. But till the day my mother died, she was never physically incapacitated or mentally incapacitated. She was as sharp mentally the morning she passed away as any day in her life. Had I had to wait until she became mentally incompetent to utilize that power of attorney for her benefit, I would have never been able to use it until the day she died. Never. Sometimes that is an undue burden in not allowing your family members or your power of attorney to act for you, even if you're not mentally or physically disabled. My mother never was. Was it much more convenient for me to do those things, informing her of what I was doing with her consent, but doing them for her? Yes. She lessened the burden on me as her son significantly by not having that restriction in there. Now, this was a personal story. That's how it played out for me. Everyone has to make their own decision about whether it's important to have it one way or the other, but you do have that option. And I wanted to clarify that because some people, you may have a power of attorney or know of someone that has a power of attorney with that springing mechanism, that restriction in it. So you have to decide if that's best for you and your family, depending on who's going to serve in that role. A couple of just final facts about just the general durable POA before we shift to the healthcare POA and living will. You must be at least 18 years of age, yes, to execute a POA. All general durable POAs are recorded in the Register of Deeds office. They're the only legal document that is normally recorded in the Register of Deeds in the county where you reside prior to your death. Healthcare power of attorneys, living wills are not recorded, DNR statements are not recorded, your wills, last will and testaments are not recorded, but a general durable power of attorney is recorded. In part because the state law says there are certain transactions that if you use a power of attorney, it has to be on record. The buying or selling or mortgaging of real estate is one example. So we go ahead, as soon as they're signed, the general durable power of attorneys never leave our office. We take them directly back from the client. We electronically file them with the Register of Deeds in Greenville County, and then we send the original documents back to the client with the book and page already listed on them of exactly where you can find them in the county records from that day forward. So it's important to have them recorded. And if you have a power of attorney, either created in South Carolina or from another state, it's important to consider having that recorded. And it could be a power of attorney that's 10 years old, but that's okay. It can still be recorded as long as it meets the requirements. And I mentioned out-of-state POAs. We often get the question, someone moves to South Carolina and they say, well, I lived in Georgia for 15 years and that's where I had my will and my power of attorneys and living will prepared. Are they still good in South Carolina? And most often the answer is yes, they are. Most often your documents from one state to the next are still considered valid. They're legal. The only change that sometimes prompts people to update or change their documents is they do want to make a change to the document itself. They want to name someone else as a beneficiary in the will. They want to change their power of attorney appointment. As in, I've lived in Georgia where my son lives for 10 years and I made him my power of attorney. But now I'm in Greenville to live near my daughter and her family. I want to make her my power of attorney now because this is where I plan to stay. That's common. So we do update. Even though the Georgia power of attorney under that scenario is still legal, it's valid, but there's been a change of circumstances. And with any legal documents that you have, death, disability, or divorce, I call them the 3 big Ds, are often circumstances that will prompt you to want to update your documents that you have. And I will say what's very easy, if you as a person or within your family is dealing with death or a disability due to an illness or an accident or due to divorce, those are all pretty traumatic emotional events. You're just coping with life and supporting your family. The last thing on your mind is how that could impact your documents that you took to the safety deposit box at the bank 10 years ago. But we do encourage clients every 2 to 3 years, pull out your documents, read through them, make sure there has not been any changes in your life that would prompt you to want to change those documents. So that's important as well. But there again, a POA could be valid until the day you die. If you signed it today and you lived 20 more years, presumably that power of attorney could serve as your POA until the day you die. But it does become void. It is terminated the moment of death. And some people have the misconception that, and I'll use my family, my sister. Let's say my mother had made my sister her personal representative, to her executrix, to handle her estate after her death, but she named me as her power of attorney. That's a very, very big distinction in the role and responsibilities that we have. I personally, as power of attorney, would have the authority to make decisions for my mother during her lifetime. But the moment of death, the personal representative, the executor, takes over and becomes the person in charge. And in some families, I've seen the misunderstanding that the POA just thinks they continue to be in charge. They continue to make all the decisions after someone dies that they had been serving as POA. And now, if my mother had appointed me as her personal representative and her POA, it would have been the same person. And sometimes it is, but not always. So that is a distinction I wanted to make as well. I want to turn over to page 3, which is healthcare power of attorney, because there are some differences I want to bring to your attention regarding these. I mentioned a moment ago that the general durable power of attorney, having that springing mechanism, that it can only be used after you become mentally or physically incompetent, was an option. And it is optional under a general durable power of attorney, but not under a healthcare power of attorney. The healthcare related decisions are governed, and I put the code section because once in a while I'll have somebody that likes to go home and look up a South Carolina code section and want to read it. So I put it in there at the top of page 3. The durable power of attorney for healthcare decisions are governed by that specific section of the South Carolina Probate Code. And the healthcare POA, which only deals with medical decisions, no legal, no financial, only medical related decisions, does have a springing durable feature in it, which means the healthcare POA should only be used when the principal, the person, can no longer make their healthcare decisions themselves. Now, I had a healthcare power of attorney for my mother as well. But I mentioned a few moments ago, she was mentally very sharp. Me or my sister went to every doctor's appointment that she had the last 2 years of her life. Not once, after a doctor or physician's assistant or nurse came into the room, addressed my mother as Mrs. Brown, and began conversing with her, did they ever look to me or my sister to make a healthcare related decision. They knew she was fully competent and able to make her own decisions. They could have cared less whether we were there. Now, there were brief times where my mother was in ICU, she was unconscious, and that was a different scenario. Because she now, even though it was temporary, she did not have the ability to make those decisions, and the doctors and the nurses did not hesitate to allow us, to keep us informed first and foremost, and allow us to make any decisions that were necessary. But a healthcare power of attorney is only to be used when the principal, the person that's given the authority, is no longer able to make those decisions themselves. So as long as they're able, they will make their own medical-related decision. That's what the state law says. And healthcare facilities and doctors, nurses in this state and many others know that that is our law. And that's how they will interact. Now, you may have experienced something within your own families that was a little different, and I know there are exceptions to every rule, but that is a common course of practice of how healthcare facilities and doctors are going to administer care and who they want involved in that decision-making process. As I stated earlier, in terms of the healthcare itself, our state healthcare form does comply with HIPAA, and South Carolina has, unlike the general durable POA, South Carolina, our legislature, has adopted a healthcare form. They have reviewed it, they have approved it, and said, we are going to adopt this and suggest that all of our residents consider using this form, this medical directive, as their healthcare POA. You don't have to have the South Carolina form to have a valid healthcare POA. As I mentioned, many people move into South Carolina already with these medical directives. That's okay. But the state has said, we approve this form and we encourage our residents, our citizens of South Carolina to consider using it as one of their medical directives. So it is a state-adopted form. And as I mentioned, it does require 2 witnesses. It does not have to be notarized, and there is an affidavit statement that requires at least 1 witness to attest that the person signing the document was of sound mind, under no duress, fraud, or undue influence. And the sound mind, I'll key in on for just a second, goes back to the capacity comment I mentioned earlier. You must have the legal capacity to execute any of these documents. You must know what the document is in general terms. You must know who you are giving this authority to and what authority you are granting to them, whether it be a general durable power of attorney or healthcare power of attorney. That's very important. And that's one of the risks that some people take by putting off preparing these documents. Because everyone in this room walked into this room, many of you drove to this meeting today. You did not need a power of attorney or a healthcare power of attorney today. But you all, and I'm giving everyone the benefit of the doubt, you're of sound mind and you have the ability to execute these documents today. But things change overnight. Illness or accidents especially are 2 of the main factors that your life or the life of a loved one could change overnight. And I don't like having to have the conversation with a client, which has happened. They come into the office. They're very distressed. I need to meet with an attorney. My mother has suffered a stroke. She was rushed to the hospital. She is in ICU. We're not sure how severe this illness is. The doctors have asked if she has a power of attorney. I said no. They said, you better talk to an attorney. So I'm here today. I need to get a power of attorney for my mother. It's difficult to have to tell someone in that situation. When they need that document the most, you have to say, I'm sorry, but it sounds like your mother can no longer sign that document. And she may never recover to the point where she can sign that document. And the conversation quickly turns to what is our other option? Looking to go and file a legal action and spend the time and the money and the court hearings to get that put in place. Because that family did not sit down and have that crucial conversation before that traumatic event. They did not sit down and think, if my life changes, who do I want to step in? And I tell clients that have children, if you want to give your children a gift, if you want to lessen that burden on them, you will consider the benefits of having one or more of these power of attorneys in place. But what happens if you don't? And again, as I've said, there are many times, and I'm not going to ask for a show of hands today, that people don't have health care power of attorneys. Well, the state law does, they're thinking for us in some respects. And it's called the Adult Health Care Consent Act in South Carolina, which states if a resident of South Carolina has a medical emergency, they need a medical decision made for them, and they do not have a health care power of attorney or medical directive, the state of South Carolina has determined who will make that decision for you. And I've listed them at the bottom of page, I believe it's 3, although they're not numbered. Right above where it says living will is the priority that the state of South Carolina lists for who will make your medical decisions for you. The first is a court-appointed guardian. The second is a healthcare POA, which would be you having taken the initiative to have a healthcare POA and designate someone to make those decisions for you. They would probably be the number one priority. But if you don't have the POA, which is the scenario I pose to you, normally it's your spouse, as long as you're legally married, regardless of happily or unhappily, legally married, they have the authority under state law to make those decisions. If not them, it's your adult children. Equally, not your oldest, equally. Now, I'll give you 2 simple scenarios. One client decided to have a health care power of attorney and the other decided not. Now, I share with them the same information, much of which I've shared with you, because I think it is a very personal decision. But I just like to share more about the document and some of the consequences of having it and not. And I shared with one husband and wife, and they say, we have talked about these decisions, Mr. Brown. We are very comfortable with each other making these decisions for one another, for each of us. And we have one child. We love her. We trust her. She lives in Greenville. She does things for us now, and we know she's going to do everything she needs to do for care for us if needed in the future. We are fine with her making our medical decisions for us if we cannot make them ourselves. And that's exactly what the state law of South Carolina will allow. I don't anticipate that husband or wife will ever have an issue making decisions for one another. And I don't expect their daughter will ever have an issue stepping in at some point in the future if she has to and making decisions for her husband, or her father, mother, or both. That's one scenario. They decided that they did not want the health care power of attorney. But now I had an 85-year-old widow in my office a few months ago, and we started talking about health care power of attorney. She was a widow. She had no spouse. She had 5 grown children, ages, and I remember this just because I've used this example, from 48 to 63 in age. 48 to 63, 5 children. So I started explaining the health care power of attorney, and I said, Mrs. Jones, that wasn't her name, but Mrs. Jones, I want to talk to you about a health care POA. You don't have a spouse. If you do not have a health care power of attorney, the state of South Carolina will allow your adult children to make your decisions for you. She stopped me mid-sentence. She said, Mr. Brown, that's when she informed me. She said, my children range in the age from 48 to 63. She goes, in 63 years, they have never agreed on anything. I don't expect them to start agreeing on my medical care and well-being now. She goes, I have one daughter. She's been a nurse for 25 years. She will make any and all medical-related decisions for me. Draw up the document. I said, Ms. Jones, I understand exactly what you're saying. And that's exactly what we did. She took the initiative. She was proactive. She said, I'm going to name the person. The state of South Carolina is not going to tell me who's going to make my medical decisions. I'm going to make that decision. And she did. And left that office the day she signed, hopefully with the peace of mind that she had made the decision she wanted to make, and she had put the person in charge that she knew would carry out her wishes, that knew her view, her medical wishes, and would carry them out. And those decisions do lead all the way up to the last document I mentioned at the bottom of the page, which is living will. Now, the big name for a living will is a declaration of a desire for a natural death. That's how the state of South Carolina listed in our statutes. And it's another state-adopted form. But the living will serves one primary purpose. It allows you to put down in writing the last decision that will be made regarding your life, normally ending your life, when you can no longer speak for yourself. That's the purpose of the living will. The health care power of attorney could cover every medical decision that needed to be made for you from today until that last decision is to be made. And under state law, the last decision, the living will, if you have one and it's in writing, the living will supersedes your health care power of attorney or any other medical directive that you have. Now, not everybody chooses to have a living will, and that is a very personal choice. If you don't have one similar to the health care power of attorney, or I should say, under the Adult Health Care Consent Act of South Carolina, state law says your spouse, your children, your parents, sibling, in the order listed, will be the ones to make that decision. Again, I think it's a matter of you deciding whether you want to make that decision. And even if you feel like your spouse or children would make the same decision you would rather have it in writing. You would rather have them be able to hold that piece of paper at the time that they are being called upon to make that decision or consent to medical treatment being withdrawn. And they will at least know that at some point, years ago, that mom or dad or husband or wife made it very clear what their decision was. Now, my mother had a living will as well. And we had the exact situation with her. Even though her health was declining, she had a traumatic event that left her in a permanent state of unconsciousness and on life support. And she had a living will. Her treating physician knew she had a living will. But still, from a practical standpoint, families are involved in that decision. And some of you may have been involved in that decision with your own families. Because hospitals and doctors know there's a lot of legal liability tied to ending life. And even with the living will document, they want the next of kin, the spouse, they want the children, all the adult children, to be informed of that parent's condition and consent, even with or without the living will. So I am fortunate, and I say it a year later, I can say I feel fortunate that my mother had the living will. Not that me and my sister struggled with that end-of-life decision very long. And I think we would have come to the same decision within the same time frame, with or without having that living will document to rely upon. But it does give some people peace of mind when you look back on a very emotional, traumatic event and a very big decision that you know you were carrying out, as difficult as it may be, you know you were carrying out the decision of that loved one because they put it in writing. And beyond that, hopefully, if you have a living will, you will still have that conversation with your spouse and your children and let them know. Let them know you have the document. Let them know why you executed the document. Not only did you want your wishes to be known and in writing, but in hopefully some small way, you wanted to provide them comfort and peace of mind that if they are put in that position, they will be doing exactly what you would have done if you could speak for yourself. The importance of these documents, I think, at the end of the day, you have to decide how prepared you want to be. You have to decide how prepared you want your family to be by being proactive in making these types of decisions for them, for yourself and for them as well. So I will encourage everyone to consider it. I'm going to conclude my remarks and take just a couple of questions if there are any. I will reference just the last page. I won't go over it in detail, but there's one more page. And I know many of you haven't had homework assignments for probably many years. I still cringe when I hear the word, but I'm going to say, if anything, this last page is a homework assignment for you. What I mean by that is if someone has to step in and serve as a POA, take over the family business, pay your monthly bills, or they have to step in as your personal representative after your death. We have compiled in our office a list of information that we feel is very important for a power of attorney or a personal representative of an estate to be able to access. Now, I don't mean that once you compile this information together, you need to give a copy of everything to your children. Not necessarily. The information is it's probably not necessary that they have it today. But it is important that they be able to access it if and when something happens to you unexpectedly. And maybe you're serving as a power of attorney for one of your parents or siblings. Then I would encourage you to send this list to them and say, please begin to compile this information together in one central location, file or otherwise. For instance, when I mean knowing where something is, if I, and being my mother's power of attorney and her personal representative for her estate, she had one chest of drawers in her home. And I knew that it was in her home. I had access to her home. I knew which room to go into. I knew which desk it was in. I knew which drawer to open and which file to look in. That specific. That's important because often people will need things quickly and unexpectedly. They don't have to have it in their hand right now, but they need to know where to obtain it. I just encourage you to take that list home, look through it. You may have certain things that you want to add to the list and everything won't be applicable to everyone. But we do feel like that will put a POA, a family member, or a personal representative in a much better position than they would be otherwise of wondering, what else did mom or dad have? What am I missing? What do I not know about? You can save them hopefully asking those questions by keeping this information, going over this information with them, and them knowing it where it is. Thank you again for your attention. Hopefully the information was helpful, and have a good afternoon.